I'm Jacopo Ciani, a research fellow at the University of Turin, Italy, and I have the pleasure to moderate the panel, which has been co-organized by my fellow colleague at the University of Turin, Massimo Durante, which is with us today. Thank you very much, Massimo. Ugo Pagalla and Ludovica Paseri, which unfortunately cannot be here today. What are we going to talk about today? As general-purpose AI systems like large language models and foundation models become more embedded in everything, they carry significant risks, especially when it comes to fairness, accountability, and human rights. Indeed, GPAI systems are trained with massive data sets scraped from the internet, raising serious questions not only about consent, privacy, data ownership, but also about discrimination. And unlike traditional forms of discrimination, it may be invisible, automated, and difficult to contest. This is, roughly speaking, the core of our panel, which brings together experts to explore this complex intersection. We will discuss how bias and discrimination manifest in GPAI systems, the regulatory challenges of enforcing data protection, the AI Act and discrimination law in this context, and what concrete steps developers, regulators, and society can take to build a more transparent, fair, and accountable AI. So with that, let me introduce our panelists. To begin, we are fortunate to have with us Dr. Monica Senor, a distinguished expert in privacy, digital rights, and the legal implication of AI systems. Monica is a legal officer at the Italian Data Protection Authority. She is fellow of the Nexus Center for Internet and Society of the Polytechnic of Turin. Today, Monica will be speaking on the topic discrimination, law, and code from a data protection perspective. Monica's intervention brings a crucial dimension to the discussion, how the architecture of AI system, the code, interact with legal principles, particularly those enshrined in data protection laws, such as the GDPR. Please join me in welcoming Dr. Monica Senor.
Thank you very much. First of all, I would like to thank you, the University of Torino, for organizing this panel and inviting me. It's a pleasure to be here at the CPDP to discuss such an interesting issue as discrimination in the age of GPAI with all of you, both the speaker and the audience. And as Jacopo has just said, just few words to introduce myself. I'm a legal officer at the Garante, so the Italian Data Protection Authority, since 2018, but I'm a former criminal lawyer. So this is my professional expertise. And as I'm a legal officer at the Garante, I have a disclaimer to tell you. Here today, I'm not as a Garante officer, but I'm as Monica. I'm just Monica. So the opinion that I will share with you and my position are strictly personal. It's a disclaimer that, as you can imagine, I have to do. And so that's done. Well, my speech, it's well, splitted, I would say, in 3 steps. I will try to go through my presentation by 3 steps, talking about discrimination and law, discrimination and code, and discrimination in the age of general purpose AI. Well, let's start for the very beginning. I think that it's a good thing that I'm the first speaker, so I will try to give to pose the basis on the issue, the topic. Discrimination, as you know, is based on bias, and bias is inherent in all humans. In fact, we talk about cognitive bias. So humans have bias strictly related to their own experience, education, living environment, age. In a nutshell, bias comes from our personal relationship with the world, from, I would say, from our bubble. And not all bias is discrimination. Only bias that could cause harm. So this is important to say that the bias are inherent to human, but not all bias can cause harm. One of the pillars of the rule of law is equality. It comes from the French Revolution, liberté, égalité, fraternité. Equality before the law means that law shall grant the absence of any discrimination. I'm a former lawyer, that's why I said this before. In every Italian courtroom, one can see la legge uguale per tutti. So everyone is equal before the law. This means that also the enforcement of the law shall grant the absence of any discrimination. Article 21 of the EU Fundamental Rights Charter states that any discrimination based on any ground such as sex, race, color, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age or sexual orientation shall be prohibited. The Article 3 of the Italian Constitution states something similar with a caveat. The Article 3 states all citizens have equal social dignity and are equal before the law without distinction of sex, race, language, religion, political opinion, personal and social condition. But the caveat is, it's very, very important. It is the duty of the Republic to remove those obstacles of an economic and social nature which constrain the freedom and equality of citizens. So bias is inherent in humans, but law shall go over individual or group bias in order to guarantee equality. So first takeaway on discrimination and law. Non-discrimination law are policy rules that aim to solve discrimination caused by human. I will add ex ante, a rest before bias cause damages. Let's move to the second step, discrimination and code. And let's talk about algorithm. Disclaimer, I'm a legal, I'm not a technician, so I hope not to make so many mistakes, but a professor, a friend of mine, a professor of informatics, explained me this important difference that is between mathematical algorithm and computer algorithms. So mathematical algorithms enable humans to solve problems. Computer algorithms are written and used to make a machine solve a problem on behalf of human. I hope this is correct. It was very, very important to me to understand this step. So the point is that algorithms are written by humans to facilitate other humans' life. And moreover, algorithms make decisions based on the input data they receive. The impact of bias on algorithms is therefore double. Bias comes from human coding and from input data that are generated by human as well. So the risk of discrimination in algorithm is double. The question is, from my point of view, if discrimination is caused by tech, can it be solved by tech? The answer, in my opinion, is no, it can't. Code causes discrimination by itself on the basis of coding and input data. Both sources of bias are human. Code cannot fix human bias by itself. So humans try to solve discrimination caused by the code by further coding. So the second takeaway from my point of view is code cannot grant non-discrimination as it causes discrimination. Human intervention is needed to try to solve discrimination caused by the code, and I would add ex post. So in a second time, this is the difference between discrimination and law. As a consequence of this second takeaway, I would say that in past years, data protection analysis has been focused mostly on Article 22 of the GDPR, on automatic decision making. So decision that based solely on automated processing. The EDPB, in the former working part in 29 opinion 251 of 2018, gave a broad interpretation of the individual right provided for by Article 22 by stating that Article 22 does not apply only when actively invoked by a data subject, has Article 22 established a general prohibition that applies whether or not a data subject takes an action regarding the processing of his or her data. According to this interpretation, Article 22 is deemed to be not only a right, but a prohibition. And this is the interpretation make Article 22 very similar to Article 11 of the Law Enforcement Directive that provide for a general prohibition. So this general prohibition is provided by law in the HAL-ED and by interpretation in the GDPR. So Article 22 is strictly linked to the human intervention on algorithm. But we have to move forward because things changed changes a lot in the last 2 years with AI, and namely with general purpose AI growing implementation. Savasandir, that general purpose AI has emphasized discrimination issues. Let's consider a generative AI system. LLM models underpinned in these systems are trained on a huge amount of data. As general AI provider says, the more data an LLM model is trained with, the better it works. Let me give an example. As you know, Meta is going to use Facebook and Instagram first-party data to train Meta AI and other AI models at Meta. Meta sent a notice to users stating that all data from the creation of user account will be used. This means that data from the launch of Facebook and Instagram could potentially be involved in the upcoming data processing. Well, assuming that Meta aim is only to improve local languages, let's just assume this, only to improve local language. One could say that the more data is used for training, the more likely is that Meta AI will be able to interact with user in local languages. But the languages are alive. They change a lot, especially common language. I'm aware that certain words that I use as middle-aged woman are not used by young people anymore. So are we sure that even on only considering a linguistic profile, a huge amount of data, regardless they are old or recent, will provide for a better AI service? How much accurate Meta AI will be using historical first-party data for training purpose? So, as you have understood, the principle of accuracy pursuant to Article 5.1d of the GDPR is the new data protection focus regarding GPAI. Accuracy is usually referred to data input. The quality of data input is paramount for an AI system to be accurate. This is true, and that is what happened for sure in the so-called narrow AI, for example, a health AI system. The quality of data is strictly related to the specific purpose of the AI system. General purpose systems are intrinsically generalist. Being generalist implies that to have more information and less accuracy. So the first, well, just another, yes, so the time is very strict. So accuracy is referred to data input, but also to the output data, so the outcome of the general AI system. So general AI have multi-layer bias sources, and any attempt to grant non-discrimination may result in a potential increase of bias. Let me add the last element, I promise, is fairness. The principle of fairness pursuant to Article 5.1a GDPR is an overarching principle which requires that personal data should not be processed in a way that is detrimental, unlawfully discriminatory, unexpected and misleading to data subject. The compliance with the fairness principle means that data processing in GPAI should be fair, and fair means inter alia without bias. So from a data protection perspective, accuracy and fairness principles are always being seen as consistent and complementary. But with reference to general AI, that could collide. Because indeed, an accurate general AI system trained on accurate data could result in an unfair system, insofar as accurate data are, or maybe they could be, biased. So the human intervention on output accuracy have been claimed for the system to be fair. We have to make a balancing exercise between different fundamental rights, data protection and right to non-discrimination. And we are in a position where the question that I leave to you is, what if you have to choose between accuracy and fairness? Thank you.
Thank you very much, Monica. I'm sure we will have time to get back to you in the question and answer phase. Thank you very much for reflecting on the principle of accuracy, fairness, and also for your view on the possibility for technology to solve the problem that it creates. Then we move to the next speaker, which is Bart van der Sloot, a renowned scholar working at the cutting edge of privacy law, data ethics, and algorithmic regulation, is currently associate professor at the Tilburg Institute for Law, Technology and Society, and is the editor-in-chief of the European Data Protection Law Review. If you have not already seen it, look at the journal of the CPDP, because there is a very nice interview addressing Bart and his experience with the journal and also with the Young Scholar Award. Bart intervention offers an overview on possible legal contradiction in the use of statistical data. Please join me in welcoming Bart van der Sloot.
Can I have my slides? Yes, super. So thank you for this this panel. I think it's very timely. Turin is, I think, the best city in Italy. I like it very much. And thank you for your presentation. Also, I think the Garante is one of the leading DPAs on AI right now, and you can see why. So thank you so much. So I'm gonna set my timer. I wanted to talk about what we do with statistical data, maybe other information that is relevant to governmental agencies, police, tax authority, what have you, but uses one of the grounds which are included in Article 14 of the European Convention on Human Rights or any of the other articles. Should they exclude it? Can they use it? Do they even have like a positive obligation to use that information? That is what I'm wondering about. I don't have like a very firm conclusion, but I will just walk you through my thinking, and hopefully you can add your thinking, and the panelists as well. So I'm a philosopher and legal scholar by training. I wrote a book on AI and law, and I was already struggling a bit there. I kind of reviewed in general how many of these legal doctrines apply. And I was already struggling a bit with the right to non-discrimination. How do we fit that into the AI context? I think in many ways it's not really written for AI decision-making, so we're struggling a bit. And then I was reading this book, which I can recommend. It takes a bit of a different view than the general discourse is. And this is also my struggle a bit, like, of course, we all agree that discrimination is wrong. There should be done more to ban it. But some of the calls of colleagues, politicians, academics are, I think, maybe too extreme. They call for outright banning of gathering like any of these data that might relate to race, ethnicity, gender, what have you. Or say, for example, that the application of laws should be fully arbitrary, that how police does like searches in the street or something should be fully blind. And I'm not sure whether that is helpful. So we know about these problems. I very much agree with that. I also wrote an advice to the Dutch government on how to translate the current discrimination standards to the AI context. So I'm very much aware of this side of the debate, and I want to look at the other side. Is there also another argument to be made? So suppose there is statistically relevant information that the roads in city X, 60% of the roads that need to be repaired are in neighborhood X, but in neighborhood X, and then you can fill out any of the proxies to the prohibited grounds like sexual preference. So there's a high community might be a gay neighborhood, might be an overtly straight neighborhood. Anyway, it's skewed towards a certain sexual preference. Is that discriminatory to use it? And so you can use all these kind of variations of that, right? So this book by Schauer just mentions how much our language is based in categories, in grouping. So, of course, if we talk about books or a book, it's not about this specific book. It has a general category book that kind of binds all these books together, but it does injustice in a way to this specific book. When I talk about a tree, it does not do justice to the tree. And it's not, it lays an overlay on reality in a way that you impose a concept on reality rather than taking reality as a bundle of information points, which is total chaos if you approach reality like that. So you need these concepts, you need these overlays to make sense of the world. And we use that for everyday judgments in a way that does injustice between brackets. So for example, July is a hot month or something, or the hottest month in the year. Is that always the case? No. Maybe sometimes August is warmer. There have historically been very cold Julys. And it also depends on where you are in the globe, whether that is true. Ferraris are fast cars. Many times that's true, but there are also Ferraris that are not so fast. They're very old or something, or almost broken. So our everyday language is just based on these categories and general truisms about these categories, without which we cannot really function, he says. We use that for animals. We have no problem with that. Making groups, if, I don't know, pit bulls cause harm in restaurants, then they might be banned from restaurants, for example. Not all pit bulls are aggressive, but maybe of all the aggressive incidents that have happened with dogs or pets, the pit bulls were mostly involved. So you can see how that works, and also for law, of course, it needs to be general, which is not really general often in that it applies to everyone and anyone, both because it's speciesistic, so it only applies to humans. Even general laws about highway speed limits affect certain people more than others, car owners, for example, and that means by proxy again that, for example, it has a reference to age, because youngsters do not have cars as much as grown-ups. There are gendered policies, age limits, etc. So that's all accepted. And then when we look at the applications of those laws to humans, there is where it gets tricky. And I think there are a couple of arguments for not using groups or categories when applying the laws to humans, and that is that it should be applied arbitrary or blindly, that it should be effective, and so it's very ineffective to use these overly broad categories, and that human beings, different from animals or all these other creatures, are unique beings. Like this is Kantian, Christian, what have you, premises that you should always treat a human as a unique individual, as an end in itself. So Lady Justice, of course, has the blindfold. So the argument is that laws should be applied blindly. So I think here the point is that there is an obligation on governmental agencies to restrict their use of power to that which is absolutely necessary. So they should use their force in the most minimal way possible. How do you do that? By using relevant information. If that limits the scope of the people you target, that might be an argument to use that information. Also, law demands a justification, legitimacy, and explanation of why force was used against a particular individual. Again, that means that you have to have some kind of ground on the basis of which you apply force. So you cannot do it arbitrarily or blindly because you have no explanation for it. Law and the application of law needs to be foreseeable for people. When you do it arbitrarily or blindly, you cannot really foresee it, right? And the last point is more a general point. The human rights regime, the European Convention on Human Rights, for example, in the wake of the Second World War, was mostly skewed towards preventing arbitrary use of power. The problem there was that the executive branches in many of these fascist regimes had an unlimited discretion on how to use their power. And so it wasn't impossible to foresee, predict, or prevent the use of power. So the second argument is that law should be effective, and this is not really effective to use these categories, both because there is a correlation. So we might say, goes fast. Wow. Well, I will get halfway through, but that's okay. So suppose you know a very controversial thing. The crimes are committed by mostly men, but also there's a higher percentage often of certain ethnicity. And then the argument is, well, of course, ethnicity nor maybe gender doesn't really cause the crime. It's a correlation, right? And this is a true argument, of course. But it also holds true for laws. When you pass judgments or when you make laws, you make categories which are always over and under inclusive. Many of the same problems arise when you pass individual judgments on individual persons. So suppose your brother has stolen 5 times of you. You are not sure that he will steal from you again the 6th time, right? It doesn't reduce him to a thief per se, but is that information you can use to maybe base your decisions on how to protect your personal belongings. And what is most important, I think, for humans, we think about causation differently. It's never really possible to use statistical data in any way to say, like, this is a cause. We also always think about humans as having a free will and thus being individually responsible. But the problem there is that the free will and what goes on in our mind when we make decisions is never accessible to anyone else. We don't know what goes on in a person, what really caused, between brackets, a certain person to do a certain thing. Even to them, it may be unclear because a lot of our decision-making is based on subconscious processes. So that makes it even more difficult. So, third argument is that that there should always be a case-by-case basis for application of the law. And I think, again, that is true to a certain extent, but we also expect application of law to be based on rules or guidelines. Again, they should be foreseeable. 2 minutes. Okay, so I will just skip through my slides. Is there special status for these protected grounds? Of course there are, but within the AI context, they don't really work for many reasons. If you want to know that, read the book. And so what I'm landing at is maybe it shouldn't be prohibited to use this information, but maybe there is a moral and legal obligation to use it if it minimizes interferences by governmental agencies, if it enhances transparency, foreseeability and justification of these interferences. But I would say you need certain very basic safeguards there. Namely, it should be proportional. So the percentage of prediction these statistical information allow for should be also the percentage to which that informs the decision. There should be a subsidiarity test. So if there's more relevant data points, you should use that. And you even have a moral and legal obligation as a governmental agency to find and get those more relevant data. And you can only use it to the extent it is effective. So you should do data creation, and you should also gather data about the context in which you gather those data. So you are aware of potentially discriminatory consequences. If you want to have access to the book, it's for free. So if you scan the QR code, the PDF will download. Am I still within time?
Yeah, perfect.
Yeah, super. Okay, thank you.
Thank you so much, Bart. And I can witness that the book is a must-read one, so please look at it. The next speaker is Dr. Rafael Xenidis, a leading voice on algorithmic discrimination and data-driven inequality. Rafael is an assistant professor in European law at Sciences Po School of Law and a senior expert of the European Equality Law Network. Today she'll be speaking on the topic reconceptualizing discrimination law in the era of GPAI. This is a particularly time and thought-provoking theme, as today our traditional understanding of discrimination rooted in human decision-making may no longer be adequate. Dr. Xenidis will help us rethink some foundational legal concepts. Her talk will lay the groundwork for many of the questions we will explore in the next intervention. Thank you very much. Please welcome Rafael. Thank you very much. The floor is yours.
Thank you so much to the panel organizers and to my co-panelists for this amazing conversation, and also to you for waking up so early and making it so numerous to this panel. So algorithmic systems, AI and GPAI, are increasingly embedded into what we could call regimes of algorithmic governance. Those are techno-legal modes of governance, and they change decision-making practices in key sites, for example, the border, the workplace, school, social services, markets, etc. This emergence has been traced very early on by, for example, Deleuze, who diagnosed that traditional disciplinary societies were replaced by societies of control. In those societies of control, surveillance became a key variable of social ordering. We know that this development has huge consequences for fundamental rights, and in particular, we know that algorithmic regimes of governance amplify bias, discrimination, and inequalities. Specifically, there has been a lot of work on algorithmic profiling, a bit less work on the discriminatory consequences of GPAI, but risks of discrimination are absolutely key as well. GPAI applications in particular run the risk of becoming gigantic stereotyping machines. We have been confronted with many examples in the media. Just to give you one that I think will speak to everyone, image and video generators is a telling example. We know how this fosters representations of lawyers, CEOs, nurses, for example, that are highly gendered. And we know that the representations of groups like prisoners, drug dealers, terrorists, and even Barbies are highly racist. Many other biases compound these representational harms in intersectional ways. We could speak about intersectional discrimination more. The problem being that those GPAI applications are embedded into other types of application, other types of and regimes of algorithmic governance. These contents highly shape our visual landscape, and they also influence our mental representations. And ultimately, this morphs into also distributive, not only representational, but also distributive forms of harms. You could think about those mental representations reinforcing problematic policing practices, for instance, at a macro level, but also at a micro level, the influence this has on, career choices or even self-censorship. So solutions to that, and it was interesting that Monica answered no to the question of whether technologies can solve this issue. And I think one example that highlights that very well is when Gemini, when Google tried to address those biases in Gemini. That didn't go too well. Remember the controversy around representations of Black popes, Black Vikings, Black American founding fathers, and even Black Nazis. Why was that? Because I think this example powerfully illustrates how the problem is not always a data problem, right? It's not always about garbage in, garbage out. The answer is not more data will just solve it. The question here that this example illustrates is highly normative, right? So this shows how, maybe to the dismay of computer scientists, the answer to discrimination issues is always contextual and always highly normative. So in many ways, the law is changing to adapt to these risks of discrimination and emerging practices of governance, but does the law adapt to this normative question of what is discrimination? How should we treat discrimination? Well, if we look at recent developments in EU law, we see that regulators have attempted to address these issues through different ways. We're facing a complex regulatory framework. Maybe we could say a complex regulatory puzzle that would illustrate the complexity a little more, comprising EU anti-discrimination laws, the GDPR, the AI Act, etc. And the interplay between those provisions is not always clear. And the court has been and will continue to be, the Court of Justice of the European Union, called on to foster more legal certainty. For example, the court's purposive interpretation of Article 22 of the GDPR on automated decision-making and profiling in SHUFA was a welcome development, or the recent decision in Dun & Bradstreet, Austria, on the right to explanation in Article 15 of the GDPR. Those are welcome developments. Yet, I think what this hides is that the phenomenon of algorithmic discrimination raises much deeper epistemological questions about the law and legal categories. And I think Bart has illustrated that very well in his talk. The question here is not a question of regulatory connection, as Brownsword would put it. So what I'll try to attempt in this talk is to take the possibility seriously that we're not facing a question of legal adaptation, but a situation in which the very epistemological foundations of anti-discrimination law, but also more recent pieces of legislation, have been challenged by algorithmic rationality and algorithmic modes of governance. And I'll give you two examples of that, two examples of those mismatches between, on the one hand, algorithmic forms of rationality, on the other hand, the way the law constructs reality, traditional legal categories. One is the notion of or centered around the notion of human-centered AI, and the other is centered around the notion of systemic risk that is particularly relevant to GPAI. So example number one, the analogy embedded in the notion of human-centric or human-centered AI. This has been a leitmotif in EU regulation, and it rests on the following metaphor. Regulatory endeavors must make the digital era, or the digital, work for humans. Analogies and metaphors we know are powerful framing devices. For example, Arda and Krutov have argued that analogies are used to advance regulatory narratives, and therefore they are incentives for legal actors to promote incomplete or sometimes misleading analogies that advance their preferred outcome. And I suspect this is the case with human-centered AI, right? So first of all, the notion of human doesn't reflect the unequal social ordering we're working with. It presupposes that there is an embedded form of equity or equality within this notion of human, which is not the case, we know. But also, this has made or framed technical artifacts as the target for regulatory intervention. When you say human-centered AI, the target for regulatory intervention is AI, right? The technical artifact. And if you look at the AI Act, this is exactly what the Act does. It creates a regulatory myopia that largely obfuscates the social conditions and social dimensions of algorithmic discrimination. For example, instead of regulating AI and GPAI as part of socio-technical systems, historical practices of decision-making, but also political imaginaries, right? Those systems are used in very specific ways to detect fraud in social welfare systems, to detect criminal behavior at the border, to differentiate the normal from the abnormal, etc. Those are rooted in political imaginaries. But the AI Act looks at these largely based on a product safety regulatory imaginary. And this largely depoliticizes these technologies and their usages. And as a result, normative questions of discrimination, remember at the beginning, we were faced with this notion of what is discrimination, how does it vary contextually. Those normative questions of discrimination, which often entail balancing different fundamental interests and rights, are tackled through bias mitigation strategies. For example, Article 10 on data governance. You could think about Article 9 on risk management systems, which apply to high-risk systems, or even the notion of systemic risks for GPAI, and I'll come back to that. Though the EU legislator claims complementarity between EU anti-discrimination law on the one hand and the AI Act on the other, in fact, the AI Act entrusts the industry with considerable power over definitions of key notions. For example, the definition of residual risk is also highly normative. How do you, accept or how do you define an acceptable residual risk of discrimination, right? So here we're faced with a problem, and standardization will play a large part in that, where key notions, complex notions, essentially indeterminate notions, notions that are inherently dialectic, like discrimination, need to be reduced through the standardization process to arithmetic, quantifiable, measurable, and actionable forms that the industry can then, operate on. So regulation embodies not only an effort to adapt technologies to fundamental rights, but also reflects the fact that legal categories and epistemologies also adapt to these new technologies and the framings that they embed. So the movement is bilateral. For example, standardization marks the law's adaptation to the industry's demand for legal certainty. That's the industry's concern, right? So attempts to fix and translate discrimination into technical terms that are fixed, where actually discrimination is highly contingent and its meaning can only be produced dialectically through contestation and engagement. That's the function of the law, right? So those examples illustrate a deep-seated epistemological shift in legal reasoning. The second example that I wanted to mention is the notion of systemic risk. So as you know, in the AI Act, GPAI models with systemic risks are subjected to particular requirements as per Article 55. And a systemic risk is mainly defined based on the technical capabilities of those systems. However, the notion of systemic risk embeds a problematic presumption that some forms of AI and GPAI in particular can be non-problematic, right? Can be neutral. So the reverse idea is that some of them don't display what the EU AI Act terms foreseeable negative effects on fundamental rights. Though we know that these technologies, once embedded in profit-driven structures and socio-technical governance systems, actually exploit vulnerabilities and create systemic risks of discrimination. Therefore, rather than accepting the industry's promise of a form of social tabula rasa and the presumption that these technologies are neutral, we should reverse the presumption, actually. And the notion of systemic risks could be an opportunity to reconceptualize algorithmic discrimination around the notion of systemic discrimination. Why would that be useful? For two reasons. It would allow us to rethink the presumption of agency that is absolutely key in discrimination law. So on the one hand, discrimination law posits socially salient groups based on age, based on gender, based on race. But this form of collective recognition that conditions the activation of discrimination law, you have to identify to a group, right, to claim discrimination. This is undermined by forms of clusterization or clustering that we know are at the core of algorithmic technologies. So the groups that ensue are very different from the groups posited by discrimination law. They are elusive, inferential, infrastructural publics, or phantom publics, to use a term that colleagues have used. At the individual level, data-driven profiling performs individualized forms, but never individual forms. So we're faced with data doubles that embody forms of stereotyping, but never recognize individuals in their own singularity. Bart mentioned it earlier. And that undermines the possibility of individual agency, right? We're in a world of epistemic fragmentation where algorithmic opacity prevents us as individual claimants from, for example, bringing proof of discrimination, right? So with the notion of systemic discrimination, we bypass this problem of agency to a certain extent, right? The second advantage, let's say, that this would have is that it would allow us to rethink responsibility along the AI and data production value chain. And here I want to leave you with a proposal. There's one concept that has not yet been invested by the Court of Justice in European law. It's the notion of instruction to discriminate, right? And in a context of systemic discrimination, this notion of instruction to discriminate would allow us to reverse the presumption of neutrality by saying those technologies feature a systemic risk of discrimination. Therefore, they should be seen as instructions to discriminate. That would echo something like Young's concept of structural injustice that invites us to rethink responsibility based on notions of power rather than traditional legal notions of causation and individual fault or individual negligence. And I'll leave you with this proposal. Thank you.
Thank you very much, Raphael. Rounding out our panel today is Stefan Verhulst, if I'm not wrong. A leading expert in using data and technology for social impact. He is the co-founder of several research organizations, including the Governance Laboratory at New York University and the Data Tank in Brussels, where he works on how data and AI can be responsibly leveraged to serve the public good. He is research professor at the Tandon School of Engineering in New York and the editor-in-chief of the journal Data and Policy. Today, Stefan helps us zoom out and reflect on how is changing the concept of self-determination. Thank you very much. Please join me in welcoming Stefan.
Great. I will try to break the cycle a little bit by standing up. My parents always said, if you have something to say, you better stand up. And so that's what I will try to do. And I think it's very typical to have a session on discrimination in this room. I felt it's almost like discriminatory to actually not be part of the real thing happening over there. So I thought it was actually very symbolic to have this session here as well. And I will be trying to be very quick because time is running out. And we've heard already a lot of interesting talks, which from my point of view were all about kind of what was mentioned, really power imbalances, power asymmetry in the environment that we have, the need for actually human interventions, but then the question is, or human oversight. The question is, of course, who are the humans that will provide oversight? And that's quite often unchallenged. And also kind of a balancing, rebalancing of that, well, anyway, what is positive, what is negative, but the question is who determines what is positive, what is negative. It depends on context as well. And that's what I will try to also reflect on, because what I'm really interested in is, of course, obviously discrimination, but also the connection between discrimination and equity, and then, of course, the connection between equity and agency. And of course, there are very strong connections there that we actually, when we talk about discrimination, we should at the same time talk about equity, and we should at the same time talk about who actually has agency in society that leads to potentially inequities, that then subsequently leads to discrimination as well. And I think we cannot separate those kind of concepts from each other. And I will specifically focus on agency, because I think that's a real challenge, which we already heard in the kind of data and AI lifecycle. And from my point of view, what we see is actually a fundamental agency asymmetry, right? Not everyone, right, and especially not those that are affected, have actually agency to inform, for instance, how the life cycle, including the data and also the AI life cycle, will actually benefit them, or have agency to rectify if the life cycle to a large extent harm them. And I do emphasize life cycle, because quite often, especially within the concept of data protection, which is also in the title of this section, quite often we focus on one element of the life cycle, which is collection, right? Which is all about having some agency about how data is collected, for what purpose. But ultimately, we're talking about the life cycle where multiple decisions are made, and if you only focus on kind of the collection, like anyway, surveillance, for instance, but not about anyway how it is processed, how it is reused for training, for instance, what is the model being used, and how do we actually inform the model? Because the model, it's not only the data that might have bias, the model might have bias as well. And then how is that being reused? I think we really need to have a kind of cross-life cycle approach with regard to agency, and also cross-life cycle approach with regard to discrimination, because you have discrimination at every part, and bias, by the way, at every part of the kind of the life cycle. So we need to go a little bit beyond kind of the data collection as well. Now, when we talk about agency, and especially GDPR has a series of agencies, of course, that they are integrated. But of course, everyone is concerned and focused on the last one, which is consent, which is kind of the main vehicle in kind of the data protection environment to provide agency, right? If we then look at kind of innovations in agency, then a lot of it is about how do we redefine consent, or how do we make better consent? How do we go beyond kind of the long-winded forms that inform consent, and I think the next panel here will actually focus on that as well. But then, of course, there are other efforts where, well, perhaps we can have agency by making data property, which I have strong reservations with, or we need to have technology that controls, anyway, that the individual has control about the agency, control about their data, and only can share, anyway, if it aligns with their individual preferences. And then, of course, here in Europe, everyone is kind of obsessed about sovereignty as kind of a way to provide agency. From my point of view, all of these have kind of limitations, especially because those limitations are very much limitations connected with our kind of model of choice, right? Because all of this is about, anyway, how do we prevent choice as an agency, right? And I think choice as an agency is actually a very limited perspective of agency, because it is typically kind of a binary approach. Yes or no. And that, from my perspective, is actually not really agency, right? It's just kind of, anyway, you have a limited choice, and then, anyway, that's your agency. It's kind of very limited. And that's why I think consent, to a large extent, is actually a very flawed mechanism to deal with the agency issues. And it's also a very flawed mechanism to deal with discrimination, as kind of, especially also if it's systemic, right? To actually have this as kind of a way to provide agency. Other reasons why it is problematic from my point of view is because, anyway, and there are many other reasons, but the one that I would emphasize is that consent is always individual, right? And from my point of view, relying on a bunch of collection of individuals to have this kind of balancing act that we were talking about, right, without having a collective discussion about what is actually the balance, from my point of view, is actually very problematic, right? Because you rely on individuals to make actually decisions that impact groups and societies, right? And more importantly, data is actually also relational, right? My data, right, now, anyway, if I go out and they say, well, where were you today? And, well, my data already disclosed things about this panel, right? And so if I say, well, it's fine to, anyway, to share that, that also means that I have made decisions for all of you, right? And so I think, and that's why consent, to a large extent, is actually problematic from my point of view. And so I've written about this, that we actually, especially at the time of AI, we have, and especially within the traditional notions of data protection, which are so strongly based upon kind of notions of consent, right, as kind of the main vehicle for agency, we actually have to start really rethinking how we actually establish agency because of the agency asymmetries that we have, which leads to power asymmetries, which leads to actually the limitations on how we go about creating a more fairer approach as well, because it's also an issue of fairness. Who determines what is fair? If you rely on individuals to determine that, then anyway, I'm not sure we are going to get into some kind of a societal fairness as well. So that's why I've started working on this new principle, which is more the principle of digital self-determination. And so we've created this now international network. We've been working on that for the last kind of 4 years, which is really kind of, initially I was kind of, well, I'm not so sure, but actually it's a really, from my point of view, more compelling way to think about it, because here it's really about determination. It's not about choice, right? It's about how do we actually collectively determine what is the choices and what are the kind of preferences and expectations that we want to embed in some of this technology. And what I also like is that the notion of self is broader than individual, right? The self could be communities. The self could even be a nation to a large extent. And so the self is actually a broader approach than kind of individual consent as well. Now, the question then is, of course, how do you operationalize that? And that's also where I spent quite some time on really thinking about how do we actually operationalize the principle that really puts empowerment, determination, and a broader notion of self into context. And again, if you're interested, you can check out the paper. But here, I've actually settled on this notion of a social license, right? That we need to complement consent with actually, I'm not advocating for getting rid of consent, right? Because it's a fundamental kind of aspect of data protection. But we really need to complement it with kind of a social license for use, or a social license for a particular kind of modeling that is being applied on the data as well. And I think it's an interesting concept, social license, for two ways. One, it actually comes out of the extractive industries, right? And I've done a lot of work in the past on kind of mining and so on. And so if you want to extract assets, right, then quite often there's a requirement for having a social license for extraction, right, with the communities that will be impacted by the extraction, right? And I think it's actually a very interesting model in today's environment, because a lot of the practices that lead to, by the way, discrimination are actually extractive practices, right? Are practices that you didn't have agency over how it was used and for what purposes it was as well. The other interesting aspect of social license, of course, comes out of a social license to do business, for instance, right? Which is also pretty well established, which really goes about if you are, anyway, want to develop a business or you want to develop an initiative, you actually need to obtain a social license. And that's embedded actually in law. We just have forgotten about it, that it actually is embedded in law when you set up, for instance, a corporation, right? Now, if you're interested in more, I've just published this last technical report, which the Agence France de Développement, because my perception is that this extractive behavior is especially the case in kind of low and middle income countries, right, where there is no bargaining power quite often about how their data is being used, and where we are now looking into social license. Now, if you want to then operationalize a social license, from my point of view, we need to really start innovating in 3 ways. One, it's about how do we actually establish preferences, right? From communities? How do we go about actually knowing what their preferences, expectations, and concerns might be? The second one is how do we then document those preferences? And the last one is, of course, how do we then enforce those preferences as well? Now, as it relates to the first one, here I've tried multiple kind of initiatives in order to rethink how we go about establishing. One was kind of during COVID, we had a citizens' assembly, the first ever citizens' assembly on data reuse, right? And this was in New York. And recently, the other one is kind of how do we establish, for instance, preferences among youth about how their data is being used for algorithms that might ultimately improve services for them. But they were never asked to a large extent. And so we created this next-gen data initiative where we basically engaged with youth in 4 countries, Tanzania, Moldova, India, and Kyrgyzstan, to really try to, anyway, have a new way of establishing preferences. Now, the question is, of course, how do you then document that? And this is kind of the elements that we seek to document. And that could be in a data sharing agreement. It could be in a terms of use agreement. It could be in kind of a contractual agreement that says, look, if you use our data or if you want to use it for training, these are the conditions that collectively we have actually set up. And very, anyway, simple. It's about why, right? What's the purpose that we feel is appropriate, which also, by the way, could be a positive use, right? For those purposes, actually, we want you to use our data because we will be better off if our data is included, because quite often their data might not be included as well, right? And so on. And then the third element is, of course, how do we enforce that? And here there are multiple ways of enforcement. One that we are focusing on is actually setting up data commons, right? Where data is being governed and is being controlled in alignment with the social license, right? Where you basically can say, yes, you can use this data, right, in alignment with our social license, but in order to determine, anyway, what are the conditions for use, you actually do need to have that kind of social license establishment. Otherwise, anyway, how would you manage data commons as well? Now, there are other ways of enforcement, as I said, just terms of use, but also actually what could be interesting is that you could actually use a social license to improve the choice made at consent, right? You could actually say, yeah, these are typically the choices that are prepared for you, but we also have a third option. We actually asked people what they want, and that also is a choice that you can actually now sign up to as well. So it is actually a way to actually improve also consent to a large extent as well. So I'm going to close here by saying is that in order to tackle discrimination, we actually also have to tackle the agency asymmetry that we have, because many of those challenges are normative, and how will we make normative decisions if we don't have a collective way of doing this as well. But also we need to go beyond kind of the traditional data protection perspective, which is really agency at the point of collection. We need to actually broaden that, we need to go beyond that, and I think we need to go beyond choice and perhaps really start experimenting, but also operationalizing this notion of self-determination, which is more about empowerment, more about negotiation than about choice as well. So there we go.
Thank you very much, Stefan, also for saving 2 minutes for try to opening a very brief Q&A session, because we are the time runs so fast. If somebody would like to make a question, very quick for our speaker, yeah. Let's try to collect them. Please stand up.
I have almost no voice, but I'm trying my best. Very interesting further considerations, but I want to be pushing the problem and the possible solution further. First, we want a regulation. We have the UI Act, okay, it's being watered down. Now we're saying standards and impact assessments. Aren't we, legal scholars and policy, pushing the problem and the solution further on? What's your take on this? Thank you.
Thank you. Second question.
I think that we also need to look past the technology and at the society that we live in. For example, we know that we are in a risk society, and that is inherently biased and discriminatory in itself. And so I'm wondering that, don't you think the technology might be holding up a mirror and showing us that possibly we also need to rethink the social structure that we have in order to make sure that the technology isn't biased in itself?
Thank you very much. Yes, please.
So I come from the policy perspective from a civil society organization, and I really believe that we have to go beyond consent. I really believe that. And something that I think is being negotiated, the only thing that is being negotiated is this mandate will be the GDPR Fairness Act, and fairness is a concept that we have used, and that actually could invite this idea of going beyond consent as per GDPR and making interfaces and design fairer. I know it's not enough, because when it comes to AI, you have the problem with collective consent, but what do you think about that? Because as mentioned, it's also about policy, right? We need to translate that, and we need to convince policymakers that discrimination is embedded in the design, so we need to do something. So I would be very interested in your opinion. Thanks so much.
Thank you so much. I think we have enough. 30 seconds each. Who would like to start?
Okay, very quick reaction on regulation. I think that we are in a very challenging period. We have a lot of regulation that interplay. From my personal perspective, is the GDPR and AI Act right now, and we also need for more policies and interpretation in order to understand how to regulate these new technologies that impact so much on society. So maybe I stop here, just a quick reaction, maybe not so useful on the first question. Yes, it's a challenge. It's very interesting, but yes, it's not so easy to find answer to all these questions on law and tech in this period.
I think, and some of the questions hinted at that we need to fundamentally rethink a lot of things right now. I think AI forces us to rethink the law. Is it still fit? Does it still function the way we want it? And I think you indicated that it might not. I very much agree also as to the discrimination clauses. I think we need to rethink technology. Do we want to use it? How do we want to use it? And take more control over that. And I think we need to rethink society as well. In a lot of ways, AI just uncovers how deeply discriminatory a lot of societal systems are, and it copies that. And so it also forces us and allows us to correct those wrongs, not only in the technology, I hope, but in society as such.
I agree with the two comments that have been made in the audience. I think, the problem is partly trying to foster legal certainty when discrimination, as we, I think, all agree, is a deeply normative question. So, fostering legal certainty could also be a compliance strategy, right? But it won't function. And I agree with the comment that the answer is social. And I'd like to use 2 seconds to actually ask you a question about your proposal. Don't you think that you're also moving some of the flows of the consent-based approaches from the individual to the collective level, in the sense that, this raises really complex questions of preference formation and information asymmetries as well?
Exactly. Yeah, and I've not said that. As I said, I'm not advocating for getting rid of consent, right? So I think it's more like how do we complement kind of individual preferences with also collective preferences, right? And to a large extent, I agree with Bart, is that, anyway, we actually do need to, we have all those policies now, and we are kind of like stuck. And I think we actually really need to start thinking about how do we deal with some of the challenges, which a lot of them are the result of asymmetries in society, right? And so we have asymmetries with regard to data, who has access to data, who controls data. We have information asymmetries, right? Because from my point of view, even having a discussion about how do policies apply, we actually don't really quite often understand what are the policies and what are the practices. Most of the time we don't have the information to make better decisions as well. And then we have agency asymmetries from my point of view. But as I said, my concern with consent is that those agency asymmetries have always been kind of pushed to, we can solve that by individual agency. And I think that's kind of the limitation of the environment that we currently have. Now, there are plenty of opportunities to actually also, anyway, do some more kind of policy experimentation, right? No one says that, anyway, that there are spaces where you can actually do this, right, without violating the existing policies, right? Like, for instance, the whole issue of kind of data spaces, right? There are actually ways to there, anyway, embed some notions of digital self-determination, right? I mean, no one says you cannot do kind of collective convenings or citizens' assemblies. No one says it's illegal. So why don't we, anyway, embed that as kind of a way to make those spaces more democratic, because those are the spaces that will be used for AI. I mean, I think that's kind of the main use case that eventually will evolve. And I think there are ways to do this without changing the policies, where we actually come up with new innovations, because I think that we do need to rethink a lot of that to a large extent, and there are opportunities for doing that. We don't need to wait for another policy to do so, right?
Thank you very much, Stefan. I'm sorry we have to stop here. We have a very big program for the full day. My big thanks to the speakers, but most of all to you that come here so early in the morning. A big applause to all of you. Thank you very much. I'm sure that who have some other question may address our speakers in front of a coffee. Thank you very much. Bye.